On April 5, 2018, a grand jury in Hillsborough County, Florida, indicted Ronnie O'Neal III on 7 serious criminal charges stemming from a violent and disturbing incident that occurred late on the night of March 18. Those charges included 2 counts of first-degree murder, attempted first-degree murder, first-degree arson of a dwelling, 2 counts of aggravated child abuse, and resisting an officer without violence. Prosecutors alleged that O'Neal murdered his 9-year-old daughter, Renevia O'Neal, and the mother of his 2 children, Kenyatta Barron. He was also accused of attempting to kill his 8-year-old son, Ronnie O'Neal IV, and setting their family home on fire. According to the arrest affidavit, Hillsborough County deputies were dispatched after receiving multiple 911 calls. One call came from a woman pleading for help, stating that she had been shot. Another call came from O'Neal himself, who claimed he had been attacked and admitted to killing the victim. When deputies arrived at the scene, they found Kenyatta Barron's body in the front yard of a neighboring home. She had suffered fatal gunshot wounds and stab injuries. Inside the residence, deputies observed an active fire. First responders also encountered Ronnie O'Neal IV, who had sustained severe stab wounds and burns. He survived after undergoing emergency surgery. Later, 9-year-old Renevia was found deceased inside the home, having suffered multiple stab wounds. On May 21, 2018, the state of Florida formally filed its notice of intent to seek the death penalty. In October of that same year, the court determined that Ronnie O'Neal III was not competent to stand trial and ordered him committed for competency restoration treatment. In June of 2019, the court ruled that he had been restored to competency and that the case could move forward. The case ultimately went to jury trial in June of 2021. Notably, O'Neal chose to represent himself. In this episode, we're going to take a close look at his opening statement. This is the moment at the beginning of a trial when each side presents their version of the case and outlines what they believe the evidence will show.
To prove.
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers in Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence. The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true. The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta After Kenyatta Barron's call was made, now I'm calling 911. But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today. The evidence is going to show my son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial, witnessed me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini strikes on that video and audio that you just heard.
During his opening statement, Ronnie O'Neal claimed that the evidence would show he struck Kenyatta Barron only 3 times. He went even further, accusing law enforcement of tampering with evidence to make it appear as though the assault was far more severe than it actually was. That claim quickly fell apart once the medical evidence was presented. The medical examiner, Dr. Mainland, testified that he personally visited the crime scene and later conducted Ms. Barron's autopsy. His findings painted a completely different picture. Ms. Barron's right arm was broken in 2 separate places. She suffered a gunshot wound to her right shoulder and a second, larger gunshot wound to her right elbow. In addition to the gunshot injuries, Dr. Mainland testified that Ms. Barron sustained extensive blunt force trauma to her head. She had more than 15 separate lacerations, multiple abrasions and contusions, and 6 to 7 fractures to her skull. These included a fractured jaw, fractured facial bones, and multiple fractures at the base of the skull. Several of her teeth were also missing. Based on these injuries, Dr. Mainland concluded that Ms. Barron died as a result of blunt force trauma. The court ultimately found that there was clear and convincing evidence that Ronnie O'Neal had beaten her to death, likely using a shotgun that investigators later recovered shattered into multiple pieces. This testimony stood in direct contradiction to O'Neal's claim that he struck her only a handful of times, severely undermining his credibility from the very beginning of the trial.
Pieces.
And they added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it consecutively over and over like Allahu Akbar, which I may have said once or twice. But they wanted to make me seem like a terrorist, and so you hear it 8 or 9 times, and you hear me calling Kenyatta Barron a bitch and a whore. The evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile. The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made, because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence. The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original cause, that's what the evidence is going to show. The evidence is going to show I look alone, but I am backed by a mighty God. The evidence is going to show I loved my children. And the evidence is going to prove to you that this whole entire case has been tampered with and fabricated before it's all said and done. I can guarantee you that. Mark my words. The evidence is going to show that they say, I said, come out here, son, and help me kill this bitch. But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa Brothers Gray, or any of her children, Mia Thompson, or Gracie Diggs, or Mr. Gray, heard me say any of those things. In fact, the evidence is going to show that Khalil Brown heard me say she killed me twice and then nothing else. The CRA is going to show, for some of you who don't know what that is, that's the criminal report affidavit that the law enforcement lead detective Thomas Dirks is the author of. The evidence will show that in that CRA, I told the neighbor, don't come outside, call 911 now. But you don't hear that on this audio for some reason. But you hear all these other things that I did not say. That same CRA will have the statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. The evidence is going to show that Mr. Harmon here says that that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of shot it was, if it was a slug shot or a bird shot, where's the missing pieces of her arm? The evidence is going to show you will not see any missing pieces of her arm in that closet where she was shot. You should see some evidence of shots, but there were several shots added to the wall to make it look like I aimed at her head. That's what the evidence is going to show. Remember I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all.
Mr. O'Neill also argued that the evidence would show that Ronnie O'Neill IV did not actually witness him beating or shooting Kenyatta Barron. According to O'Neill, his son could not reliably place him at the center of the violence. Ronnie's testimony at trial directly contradicted that claim. Ronnie testified that he saw his parents arguing, with his father holding a shotgun while Ms. Barron screamed at him. He watched as Ms. Barron ran into a closet, followed immediately by Mr. O'Neill, who was still armed. Ronnie testified that his father told him to walk around and say, Allahu Akbar. Moments later, Ronnie heard a gunshot and saw Ms. Barron stumble out of the closet and run outside. Mr. O'Neill then chased her with the shotgun while Ronnie remained inside the house. Approximately 1 minute later, Ronnie testified that his father returned, grabbed his sister Rianivia by one arm, dragged her into the master bedroom, and struck her in the head with an axe. Ronnie then witnessed Mr. O'Neill pour gasoline throughout the house and ignite it by dropping a match. Ronnie further testified that his father stabbed him with a knife and attempted to set him on fire. Law enforcement officers who arrived at the scene corroborated key aspects of Ronnie's account. They testified that the house was actively burning when they arrived and that Ronnie had suffered multiple knife wounds to his chest, neck, face, arm, and leg. He had an open evisceration of his abdomen and burns covering more than a quarter of his body. Officers also testified that when Mr. O'Neill exited the garage, he smelled strongly of gasoline and had blood on his hands and clothing. Forensic investigators recovered extensive physical evidence supporting Ronnie's testimony. They found shotgun holes in the closet doors, wadding and pellets on the closet floor, 3 spent shotgun casings along with live rounds, and a shotgun slug embedded in the closet wall with red fabric attached. Ms. Barron's blood was also found on the closet door. Investigators recovered a knife handle and blade containing Ms. Barron's blood in the garage, as well as a knife handle and a hatchet handle containing Rianivia's blood. Taken together, Ronnie's eyewitness testimony, the responding officer's observations, and the forensic evidence directly contradicted Mr. O'Neill's claim that his son did not witness the violence, leaving little room for doubt about what occurred inside the home.
Rianivia's blood.
And the evidence will show that my son said my dad shot my mom. It's the correct statement if you want to cite statements, if he even said it. Because I can guarantee you, the evidence is going to show you we are under the most corrupt administration you've ever seen in your life. I guarantee you I wouldn't waste your time. I would have already took a plea deal of some kind if I knew I did something like this, because most people don't even go to trial when they know they killed somebody unjustly. The evidence is going to show you who the killers are. I'm pleading not guilty to the charges of premeditated murder, attempted murder, aggravated child abuse or battery, arson, resisting arrest without violence. And while I'm at that, the evidence is going to show that they tased me for no reason, but they tampered with that video because they didn't want you to know the truth. And it might sound far-fetched, but I guarantee you we're going to see who the liars are before it's all said and done. Mark my words, because my family lives were taken when my daughter was done. This is what the evidence will show. When my daughter was born, it was me who gave the command, the final command to keep her alive when she was on life support. When she was born 2 pounds, 2 ounces, and couldn't breathe on her own, it was me who fought to keep her alive. But all of a sudden, I just want to take her life for no reason. I'm asserting justifiable homicide because I acted in self-defense and moved to protect myself and my children from Kenyatta Barron.
Mr. O'Neill
asserted a defense of so-called justifiable homicide, claiming that he acted to protect himself and his children from Ms. Barron. Under Florida law, however, justifiable homicide is a very narrow defense and applies only in limited, clearly defined circumstances. Florida statute sections 776.012 and 776.013 allow the use of deadly force only when a person reasonably believes such force is necessary to prevent imminent death, great bodily harm, or the imminent commission of a forcible felony against themselves or another person. The key words here are reasonable and imminent. The threat must be immediate, unavoidable, and severe enough to justify deadly force at that moment. Even more importantly, Florida statute section 776.041 places a critical limitation on this defense. A person who initially provokes the use of force is generally barred from claiming self-defense or defense of others. There are only rare and narrow exceptions, such as a complete withdrawal from the encounter that is clearly communicated, none of which were supported by the evidence in this case. In practical terms, this means that even if the jury believed some portion of Mr. O'Neill's claim that Ms. Barron attacked him, the justifiable homicide defense would still fail if the jury concluded that he was the initial aggressor. Based on the testimony, forensic evidence, and sequence of events, the state presented overwhelming evidence that Mr. O'Neill initiated the violence, escalated it with deadly weapons, and continued it well beyond any conceivable act of self-defense. As a result, the legal requirements for justifiable homicide under Florida law were not met, making this defense highly unlikely to succeed before the
initial
jury.
aggressor.
I'm going to be showing with evidence several reasonable reasons to doubt the state's allegations against me. The evidence will show that the state cannot prove that I premeditatedly killed anyone because I didn't have any time to reflect or plot and plan as if everything happened suddenly and spontaneous. I responded out of pure instinct and heat of passion, eliminating any kind of premeditated design. And let me just say, the evidence will show that since the state plans to kill me, if they can say that I killed my family unjustly, they plan to premeditatedly kill me, so they cannot say or deny me the right to premeditatedly kill Kenyatta Barron if she killed my children. The evidence will show that Kenyatta Barron had several medications and drugs such as morphine in her system. The evidence will show she had a domestic history and was arrested for domestic violence that same year. She also was born premature, just like Trinivia.
Judge, I object at this point.
I'm going to sustain the objection as to that particular argument regarding Miss Barron being born prematurely. All right? You may continue on, Mr. O'Neill.
I didn't hear him state the basis of his objection.
I've ruled, Mr. O'Neill, okay?
I understand, but I have to state the basis of my objections, right?
Well, that is correct, and I just assume what the objection is. So go ahead and state it for the record, Mr. Harmon.
Proper argument.
That's sustained.
The evidence will show that she threatened to kill me with a knife just a few weeks before the incident, and she was angry about my relationship with my other child's mom, and about the fact that we had to be cordial for our newborn son. And the evidence will show that they had been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car. Me and my son spent the whole day at my mom and dad's house working on the car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day. That's what the evidence will show. Evidence will show that my daughter was prematurely born. She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history of SLD. The evidence will also show that he was present but does not remember accurately or consistently what happened for many reasons, making him unreliable when it comes to the actual facts. He also has been diagnosed with PTSD, as he should be, because this is a very traumatic thing that he went through. He also was diagnosed with major depression disorder, intermittent confusion, and delirium. The evidence is going to show, the evidence and testimony will show that Ronnie Blair, formerly known as Ronnie O'Neill IV, may have been coached on what to say by family members.
Objection to argument.
And or law
Hold on. I will overrule the objection.
Thank you, Your Honor.
Mr. O'Neill, again, jury, this is what both sides believe the evidence is going to show. All right? And again, you will be the ultimate determiner of what the facts are. You may proceed, Mr. O'Neill.
Thank you, Your Honor. And these are also actual facts that Mr. Harmon left out when he told you about the report of his former psychologist. When he told you that he was adopted by his family members, which didn't work out as well, and he had to be placed with another family, which is now the Blair family. In that same report, it talked about how he may have been coached by family members. The evidence is going to show that my son was adopted by a detective who formerly worked in this case, whom he now lives with. And I don't have a problem with that because he needs care. But I do have a problem with Mr. Blair being involved in this case, being called as a witness, being the new father of my son, and now he's being called as a witness when he could possibly have been coached by his new father.
Objection.
Who is
Speculation
law
is
enforcement.
proper argument.
All right, and again, Mr. O'Neill, I'll rule the objection. Again, this is what Mr. O'Neill is asserting the facts will be. You may proceed.
Thank you, Your Honor. The evidence will show and prove that very vital evidence was definitely tampered with, which was a strategic omission to cover up the facts of this case, making much more of the evidence unreliable. As I know for a fact, it was altered as well. The evidence is going to show that the 911 call of Kenyatta Barron is not compatible with what Khalil Brown saw and heard outside of my home. The evidence is going to show, when it's all said and done, who put those excessive lacerations on Kenyatta Barron's face. I can guarantee you that. In this trial or the next one, I can guarantee you that. Because like I said, I look alone, but I'm backed by a mighty God. And ultimately, it will show that none of the state's witnesses can draw any conclusions, especially because they didn't see anything that refutes my self-defense claim and theory. And nor can the state do so beyond their very reasonable doubts that will be revealed. The very reasonable doubts that will be revealed by me. And that's all I have to say.
After the opening
statements, the trial proceeded for several weeks. On June 21, 2021, the jury returned guilty verdicts on all charged counts. Mr. O'Neill was convicted of the first-degree murders of Kenyatta Barron and his 9-year-old daughter, Rhianivia O'Neill, the attempted first-degree murder of his 8-year-old son, Ronnie O'Neill 4, first-degree arson of a dwelling, 2 counts of aggravated child abuse, and resisting an officer without violence. The jury also made specific findings that Mr. O'Neill possessed and used weapons during the commission of these offenses. The day after the verdict, Mr. O'Neill requested legal counsel for the penalty phase of the trial. On July 23, 2021, he was sentenced to life in prison without the possibility of parole, rather than the death penalty. Mr. O'Neill later appealed his convictions, but on August 18, 2023, Florida's 2nd District Court of Appeal affirmed the jury's verdict in full. On April 2, 2025, Mr. O'Neill filed a motion for post-conviction relief, which remains pending as of the time of this recording. In the aftermath of the case, Ronnie O'Neill 4 was adopted by Hillsborough County Sheriff's Office Detective Mike Blair, one of the first responders who arrived at the scene on the night of the attack. This case highlights the stark contrast between a defendant's narrative and the evidentiary record ultimately evaluated by a jury. In his opening statement, Mr. O'Neill framed the events of March 18, 2018 as an act of self-defense and protection, claiming he was forced to respond to a threat posed by Ms. Barron. However, as the trial unfolded, the testimony of his surviving son, the medical examiner's findings, extensive forensic evidence, and the observations of responding officers painted a very different picture, one of prolonged violence, multiple weapons, and actions that continued far beyond any plausible claim of imminent danger. Florida's justifiable homicide statutes impose strict limits on the use of deadly force, particularly where the defendant is found to be the initial aggressor. The jury was tasked with applying those legal standards to the evidence presented, and in finding Mr. O'Neill guilty on all counts, they rejected his self-defense theory entirely. The verdict reflects a determination that the state proved premeditation, intent, and culpability beyond a reasonable doubt. Ultimately, this case underscores the jury's role as the final fact-finder and serves as a reminder that while opening statements may frame expectations, it is the evidence itself that determines the outcome. If there's another case or courtroom moment you'd like us to explore, let us know in the comments below. Thank you for watching, and don't forget to like and subscribe to help foster a more informed society.